What are we doing on this case?
I would like to set the matter for preliminary examination, and I am prepared to address the bond violation.
Go ahead, address the bond violation. We'll see what we'll do.
Your Honor, with regard to the bond violation, Ms. Maxwell will admit to it. She does tell me that she doesn't specifically recall drinking. She does believe she has some mental health issues that may be a factor. She does tell me that she's made contact with Catholic Charities and left a message hoping to engage in their intensive outpatient program. He asked my court to consider letting Ms. Maxwell stay out with a scram in a home confinement tether. She's explained to me that she suffers from sarcoidosis, which is a medical condition that requires a weekly injection that has to be refrigerated, that she's concerned she may not be able to get into jail. She also indicated to me she has concerns regarding a compromised immune system. So I would ask the court to consider permitting her remain out primarily because of her health concerns.
Counsel to the people.
Your Honor, we will leave it in the court's discretion. We just been confident on several, or at least two missed. One missed test that I'm seeing, and then several non-compliant. So that would be our concern, but
She's blowing positive, and I mean, it's not like they were low levels. As she was coming down off of that, and then missing tests and the like. I understand everything that counsel's saying. You wanted this set for preliminary examination.
Yes, please, Your Honor.
All right. Your
And discovery is complete.
discovery is all complete.
Yes, Your Honor.
People have their witnesses available the 9th. All right. Preliminary examination in this matter will be set June 9th, 2026, 9 a.m. before Judge Garwood.
yes.
Judge Garwood. At this time, given the violations, defendant's bond is revoked, defendant's remanded.
Thank you, Your Honor.
Morning, Your Honor.
Good morning, sir. Your name?
First name is Kenneth, last name Mays.
Thank you.
I'm asking for an examination, please, Judge.
All right. Preliminary examination in this matter will be set while discovery is complete.
Oh, yes, it is correct. Sorry.
People would have their witnesses available the 9th.
Right,
All right. Preliminary examination, June 9th, 2026, 9 a.m. That is before Judge Barr.
I'd ask for 4 weeks, Your Honor, it's out.
4. Okay, I got you. All right. Court will adjourn the matter then to June 25th, 2026, 9 a.m. On both matters, bond will continue. Thank you, Judge. All right, thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case of Hosea Hill. People versus Hosea.
Good afternoon, Your Honor. The people.
Good afternoon, Your Honor. Edward Drucas on behalf of Hosea Hill, who is approaching.
Your name, sir?
Hosea Raphael Hill. Good morning, Your Honor.
Good morning, sir.
Your Honor, there's some additional discovery that I've been communicating to the prosecutor about. I think about 3 weeks would clear things up, so I'd be asking for an adjournment.
Probable cause conference, June 18th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank
Have a
you.
good rest of your day.
You do the same. Court calls case of the people versus William Keene.
Your
Honor, good afternoon. Joe Simon on behalf of Mr. Keene. State your name, Bill.
William Keene, Your Honor. Thank you.
Your Honor, there's a green sheet in there. The people turned over a supplemental discovery to me that I downloaded yesterday. That is, 1.6 gigabytes of information, very substantial, requesting therefore an adjournment of the probable cause.
That'll take you a night to get through.
Maybe 2.
Okay. All right. Will the 18th work for you, sir?
Should work.
All right. Probable cause conference will be adjourned June 18th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Andrew Leaney.
Good afternoon, Your Honor. My name is Coach.
Yes, sir. Court does call the case people versus Ruffini Brooks.
Good afternoon, Your Honor. Marcia Crater on behalf of Ruffini Brooks.
You know where he is?
Well, are you Mr. Brooks? No, Mr. Brooks? Ruffini Brooks? No. I'm assuming he's here in spirit, Your Honor. Unfortunately, I do not have it.
They see it. Bench warrant will issue for defendant's failure to appear bond will be set in the amount of $10,000 cash surety. That warrant will issue me.
You will not consider keeping it open to the docket. I did speak to them a couple days
Keep
ago.
it what?
Consider please keeping the warrant, not issuing it to the end of the
Okay.
docket.
Because I issued a bench warrant on a spirit.
Yeah.
Yeah, that's the reason. Yeah,
Okay, well.
all right, thanks though. Court calls the case, People versus John Thomas.
Afternoon, Your Honor, Lincoln Cook, the people.
Good afternoon, Your Honor. Joanne Prey on behalf of Mr. Thomas.
Good afternoon, Your Honor.
All right, good afternoon, Mr. Thomas. I have before me a plea form that indicates that the defendant is going to be pleading to an added count 2 of OWI, operating while intoxicated occupant less than 16 years of age, it's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also a sentence agreement of no upfront, or I'm sorry, 52-1 District Court Sobriety Court, and no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Your Honor. It is a no contest plea for purposes of civil liability.
Can I get? That's the one that, yes, no, it's a no contest plea. All right. Mr. Thomas, can you raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do so swear.
All right. State your name again for the record, please, sir.
John Thomas, John Joseph Thomas.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of operating while intoxicated with an occupant under the age of 16. That is a misdemeanor punishable by up to 1 year in jail, a $1,000 up to a $1,000 fine plus court costs. Court could also order any rehabilitative services or community service the court deems necessary, could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
I do.
All right, 2 things about it. I just have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. You understand also, sir, that while I'm taking your plea, I would not initially be your sentencing judge in this matter, and that it would be sent over to Judge Barr.
I understand that.
All
Your Honor,
right.
I believe it's Judge Bondi. Is that what you said?
No, I don't. Okay. I knew we were going to get into this. Do I have a sentencing date for Judge Bondi? Anybody?
I do not know.
Counsel, do you know of one?
Your Honor, my understanding was that you sentenced him and that he got transferred to 52-1 for probation.
Okay. And that would be beautiful if that's the way that it worked. So what we have in this with some of these sobriety courts is some sobriety courts, if I sentence at all, they will not take the case. Then we have circumstances where there are courts that want us to do the initial part of the sentencing. We've resolved that with some of these sobriety courts, haven't resolved them with others. So that part of the resolution is once I take the plea, the person's been accepted. Once I take the plea, we just send the whole thing over, but they have given us a sentencing date. That hasn't happened in this case. So, I mean, I will do whatever the parties want me to do, but what I would intend upon doing today in this case is I would take the plea. It goes because the lower jurisdiction is Judge Barr's. It would go to Judge Barr to then sentence, basically send him over to 52-1. Does that make any sense to me? No, not at all.
Okay.
But it's what I have.
I believe that is the way that it works. I think that you would take the plea. I was going to ask if you could do immediate sentencing, but given what you just said, I would want to confirm that they would take it if you did do an immediate sentencing. But if we could set it in front of Judge Barr, and if I could confirm with 52-1, one way or the other, if they want it sent there for sentencing.
Exactly.
Okay,
That's probably going to be the best bet. So
okay,
that have a date out, and then if they will take it right over, you would likely be able to get Judge Barr just to send it over to 52-1. He'll cancel the sentencing date I give you, and then the world will be back to normal. Not really.
I think
but
that's the best way to go. My inclination, I've had a lot of communication with 52-1, is that the sentence, that Judge Barr would actually sentence them to 51 sobriety court, but I would want to confirm that so there's not any issues.
Right, okay. Yeah, and that may make sense in a lot of ways. But there's a lot of other issues regarding that, but okay. All right. So, sir, after all of that, you understand that I will initially be sending you to Judge Barr for sentencing in this matter.
I do.
All right. Now, understanding all of that, you still wish to plead no contest.
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
And you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You had signed an advice of rights form, is that correct?
I have.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, inclusive of the rights that are contained in paragraph 5, which are your trial rights.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
I am.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 7389-25. Any objection to the court reviewing that report?
None from the people.
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if between the time that I accept your plea and its sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
I do, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. They're really not going to do a pre-sentence interview, but I'll order that. Sentencing in this matter will be set.
Township case or city case.
Oh, township city case gets a different date. This is, no, I'm blaming this all on Mr. Thomas's counsel. No,
Thanks, Your Honor.
I'm kidding.
Township.
I have a township.
June 16th at 10 a.m.
Say it again, June 16th. All right, June 16th, 2026. Time?
10 a.m.
10 a.m. before Judge Barr.
Thank you, Your Honor.
Bond, thank you. Bond with its conditions will continue. All right, take care.
You
Thank
too.
you, Your Honor.
Court, let's call the case. Other people versus Taisha Morgan.